Yes.
My lords, I appear on behalf of the appellant mother alongside my pupils Opros. Mr. Cook, whose counsel appears with Miss Wood on behalf of the respondent father, and you will have perhaps noted that none of us appeared at the hearing below, although Mr. Fletcher, who represented the father, provided the PD 52C document in response to the application for permission to appeal.
Yes.
Subject to your lordship's better view, I intend to be about an hour and a half in my submissions. Mr. Gupta has indicated he thinks it'll be about an hour, and I may seek a short reply of no more than 20 minutes, perhaps considering that.
Thank you.
Just by way of outline then, this is an appeal of the decision of Mr. Justice Garrido, delivered on the second day of a 2-day hearing in April. And at the conclusion of that 2-day hearing...
Can I just talk you through it? We are being live streamed,
Yes.
So initials or titles or something, but not names.
I was going to refer to the child as B.
Okay, thank you.
So at the end of that 2-day hearing, Mr. Justice Garrido made an order for B's return to Australia. B was 5 at the time. By the time the matter came before lordship, the mother's sole defence to the father's application under the 1980 Hague Convention relied on Article 13B, so the grave harm exception. And Mr. Justice Garrido concluded, as you'll see from his judgment, that the mother had failed to establish that defence, and he reached that conclusion, having heard only submissions on behalf of the parents about the evidence in the bundle. He hadn't heard any oral evidence from the jointly instructed psychiatrist. I suppose have picked up, at least from my skeleton argument, that this all happened very quickly. Dr. McDermott's report came in, I think, about noon on the Friday, that the trial, the Friday before the trial was due to begin, and everybody was at court on Monday morning, ready to deal with the case. My overarching submission on behalf of the appellant mother is that in taking the course that he did, Mr. Justice Garrido prevented himself from being able to conduct the risk assessment that he needed to undertake in order to evaluate and assess the mother's Article 13B defence. And as a consequence, he reached a conclusion on the overarching application for summary return that was, with the greatest of respect, wrong. Now, before I develop those points, I thought it might be helpful if we do a little housekeeping. I wanted to make sure that you've all received the right set of bundles. You should have a core bundle and a supplemental bundle.
Yes.
And then 2 authorities bundles.
Yes.
One main one that was prepared yesterday and handed in this morning.
Yes.
And a supplemental authorities bundle. And you have also been handed by Mr. Gupta and Miss Wood 2 additional authorities in loose leaf. The first is Malarkey and others.
Right.
And the second is re-A&R, the decision of the now president.
Yes.
Case. And finally, in loose leaf, you should have an order that I'm afraid should be in the bundle but got lost travelling from the court.
Oh, don't worry, that's yes. Thank you.
Which is the order of Deputy High Court Judges Hannah Markham granting psychiatric assessment.
Yes.
Not really a particularly document-heavy case, but can I start just by turning up some of the key documents and making a few comments about them as I do? Can I start, please, with the final order, which appears in your core bundle? At electronic page 68, paginated at 66. And can I apologise at the outset for the fact that this page number 4 is up?
Yes.
Just a few points to note about this order whilst we're on it, if I may. First of all, as is the norm, drafted by applicant's counsel, sent to respondent's counsel for comment and amendment. Paragraph 4 of that order, which we say is the record of the court's decision about the evidence issue, drafted by father's counsel, not amended or altered at all on behalf of the mother. And then if I can just invite you to have in mind the protective measures that appear at the end of that order, page 69, paginated 71 electronic. The approved note of Mr. Justice Garrido's order appears, of Mr. Justice Garrido's judgment appears at paginated 70, electronic 72 of the bundle. This was approved, amended and approved by him on the 5th of June, trial counsel having sent an agreed note of judgment to him in compliance with directions made by the Court of Appeal shortly before then. No transcript, I'm afraid, although you will have detected that a transcript was in fact ordered the transcript of judgment was ordered in the final order made by Mr. Justice Garrido. You then have the amended grounds of appeal. They appear in the bundle, electronic 15, paginated 13, amended after receipt of that approved note of judgment. Pleased to say reduced rather than enlarged in content. But they deal primarily with 4 points. The initial decision about Dr. McDermott refusing, the initial decision of the judge refusing permission for Dr. McDermott to give evidence. We say that's both wrong and procedurally unfair. 2 and 3 really can be taken together. They traverse the same territory, which is that the judge in his overall approach to Article 13b didn't do the task that he was supposed to, conclusions that were not open to him on the evidence, and having not approached it in the way that he should do, he denied himself the ability to have a clear and concrete view of what the situational return would be. And then finally, the final ground relates to the judge's approach to protective measures. You then have, of course, the skeletons filed by each of the parties, and the decision of my Lord Justice Moylan granting permission to appeal on the 2nd of July. There is a preliminary issue about the Moylan's application to adduce fresh evidence, which is, I think it's fair to say, technically but not strongly opposed on behalf of the father by Mr. Gupta.
Well, we've looked at that, and we can deal with it as may be necessary in the judgments.
We have set out in the authorities bundle the decision of Re-A&M, which appears at 353, which we say sets out the approach that was taken, but in our submission, what we say is that what has happened since the decision was made is significant. You'll see that the mother's father very sadly passed away much sooner than was expected, and the consequential impact on her mental health has been significant and severe. So we say it's very much in line with the situation that faced my lords in Re-A&M. We have, just for the avoidance of that doubt, no difficulty with the statement in response prepared by the father being allowed in as well. So, having set out those housekeeping issues then, if I may set the scene, as it were, B arrived here with his mother in February 2025. Not the first time he'd been here. This was his 6th trip in his short life, and he'd spent, depending on whose account you accept, somewhere between 22 and 33 weeks in England prior to that point. He was here for a temporary but undefined period of time in order to allow the mother to care for her elderly parents, and at that stage primarily it was the maternal grandmother who suffers from vascular dementia that the mother was here to care for. There was various back and forth about when and whether the mother was going to return to Australia, but by the time the father commenced his application for summary return, they had B and his mother had been in this jurisdiction for exactly a year. So this was not, on any view, a hot pursuit case. but it's certainly as proceeded at pace once that application was issued. Of course, the Hague Convention envisages that applications will be dealt with in 6 weeks. I'm sure my Lord would mind me observing that that's the exception rather than the rule. Issues with the mother's mental health were hinted at in her first statement. You'll see a reference to that at paragraph 45, which appears at page 102 of the core bundle. 102 paginated, 104 PDF.
Could I just say that we're always grateful for the work that goes into presenting papers for the court. And the rules do provide that you shouldn't have to go through this business of differentiating between printed and electronic bundles. It's just as easy to make a bundle which has the same numbering as one which doesn't. So,
my Lord, I can only first of all, insofar as I totally agree.
It doesn't matter at all, but it's useful to feedback that it really does help. You don't have to do.
Thank you, and we have
twice,
our apologies for the difficulties. So 102 paginated and 104 electronic, you can see that this is the mother's statement of paragraph 45. She talks about a return being catastrophic because of the emotional strain upon her and how a return and leaving her parents would affect her mentally. There is also really no more than a passing reference earlier on in that statement at paragraph 29, which is at paginated 97, electronic 99, a reference to the mother currently being signed off work for stress. Her case on her mental health was set out much more clearly in her second statement, and by that time the court had her answer as well. And it was at the pre-trial review on the 31st of March that a timetable was set for the mother to make a Part 25 application for a single joint expert to assess her mental health. And that is the order that we've handed up in loose leaf today. The order of Ms. Markham in capacity as a Deputy High Court Judge. That order provides in relatively standard terms, having been made on the papers, for Dr. Una McDermott to be instructed as a risk assessor. Was there to say perhaps description of risk assessor, not commonly commonly referred, not usually referred to a consultant psychiatrist. But the remainder of the
but it's the questions that were important in the letter of instruction.
Yes, and they are. You don't have the separate letter of instruction. I'll take you to Dr. McDermott's report in a moment.
Yeah,
but they are,
she deals with them.
They are the
No, that's unusual wording.
Few comments about this order, having described it as relatively standard. But first of all, you'll see at 7D, questions of the expert must be dealt with in accordance with FPR Rule 2510. And of course, that was never going to be possible because Rule 2510 allows for clarificatory questions to be posed within 10 days of the expert's report being received. And so ordinarily what one would do if it was going to be received in close proximity to the trial or for perhaps pre-trial review is to shorten those timeframes so that questions are raised within 2 or 3 days rather than 10. So that was never going to happen. Slightly unusual, I observed that it was left to the respondent mother to pay for the cost of the risk assessment entirely. This was a single joint expert. She is privately funded. These proceedings, the only provision for the father to pay was in relation to any questions that he may ask. And then, again, slightly unusually, reference to 7G, requiring that if the expert report is not filed by 12 noon on the 24th of April, so that's the Friday before the hearing is due to begin, an application will have to be made to rely on it. in my submission, if the court determines that an application for an expert is necessary and meets that threshold, and we know that necessary means necessary, then it is necessary, and the question is what happens to that hearing. But there we go, that was the context in which Dr. McDermott was instructed. And in fact, what you'll see if you've read the skeleton arguments prepared by trial counsel is that in the week before the final hearing, the mother conceded all of the other defences that were open to her. And you'll see reference, quite unusually, to the telephone calls took place between counsel about the mother agreeing to return, all without this very important piece of evidence which arrives as it was directed around noon on the Friday. So Dr. McDermott's report on any view is of central importance, and you'll find it at 108 electronic, 106 paginated of the bundle. Her instructions, so the list of questions posed to her by the letter of instruction, set out at paginated 111, electronic 113. And pause there to note that it is of course important that an expert is asked targeted questions about the clinical assessment and expert opinion that they are able to offer the court, so that the court has the relevant information that it needs to reach its decision and make its judgment. So this is not a general assessment of the mother and how she's doing. It's very specific. What is a diagnosis and what happens on return? And those questions from A to H are designed exactly with that clinical assessment in mind. The answers to those questions start at page 136, electronic, 134, paginated. And answered, again, sequentially, all designed teasing out so that everybody understands what the diagnosis is, what the impact of that diagnosis might be on any return, and then of course how any adverse impact to the mother's mental health might be mitigated or managed. So we start with the diagnosis. High risk of becoming clinically depressed. You will have seen that in fact the mother has already had, and this is traversed in earlier sections of this report, where Dr. McDermott sets out what it is that the mother's medical records say. But the mother had a diagnosis of an adjustment disorder with depressive and anxious mood. She did not, insofar as we can see from Dr. McDermott's report, have a diagnosis of clinical depression. And in fact, if you see pretty clear in my submission from Dr. McDermott's report that there is a high risk of her becoming clinically depressed, but she doesn't have depression. That is relevant because the father's case at final hearing, as set out in his skeleton argument, is that the mother had already had depression and had successfully recovered from it. That is a misunderstanding in my submission of the diagnosis, and if I'm wrong about that, then it's something that quite properly Dr. McDermott can help you with, certainly more than I can, or more than trial counsel. So that is the diagnosis. Next question is about causation. Fairly straightforward. Question C is really the key point insofar as it relates to the risk assessment of the mother. What is the likely impact upon her of a return? And then what would be the impact on her ability to parent B? Dr. McDermott's conclusion, which the father did not challenge then, does not challenge now, is that the final sentence of 7.31, the mother would be at serious risk of developing a clinical depression of a significant degree. So breaking that down, as we must, because we see in other decisions of this court the importance of getting the likelihood and the level of the risk not confused. This is a serious risk, so not a low risk, not a small risk, of a depression that would reach a significant degree. That is the nature of the deterioration. And then at 7.3.2, dealing with the second part of that question, it seems, depending on the nature of the depression, if moderate to severe, which it could become, and again, we know moderate to severe are not, well, they are terms that we use as lay people, but they have clinical significance, moderate and severe. They are to do with the treatment and management of these disorders. Dr. McDermott's opinion that it is more likely than not that there could be negative consequences to her emotional availability to and responsiveness to B. Well, my lords, the question that in my submission is begging to be asked is how? What does that look like? We then have a question about separation. And at E, a question about the what mitigation might be put in place, what might ameliorate the mother's mental health, what protective measures are we looking at here. Stark response from Dr. McDermott. 7.5.1, there would not be, in my opinion, any realistic supports or treatments which would ameliorate the virtually inevitable risk to her mental health. And that is because, as we see set out in that statement, the real cause of the deterioration is the anxiety that the mother has, the profound significance that this holds to her, of leaving her parents at the end of their lives. So Dr. McDermott's stark view, unusually stark, I would suggest, is that there would be no realistic support for treatment which would ameliorate the virtually inevitable risk to her mental health.
I wasn't sure when reading this what the doctor particularly meant when answering a question about ameliorating any risk. I mean, as you've just pointed out to us, there are various ways in which risk can be colloquially understood. It can be what's the sort of harm that you're talking about. It's how big is that, how grave is that sort of harm, and how likely is that sort of harm. So what do you say? Which of those was the expert answering when she gives her answer in 521?
Well, my lord, respectfully, I don't know. She says earlier on in her answers to questions, what she's concerned about is a clinical depression to a significant degree. She doesn't say in answer to this question or any other questions is whether there could be treatments in place to reduce a significant depression to perhaps a mild depression or even a moderate depression. And you'll note that she doesn't repeat the word significant in this part of her answer.
She's not here dealing with treatment, because she's dealing with treatment in the next section 7.6. So would it be, I'm not expressing a view, but would it be right to understand her as saying that given the concerns that your client has and had, that there's nothing that could be done to prevent her from facing the risk of a deterioration in her mental health? It's not, is it intended to say, if she has a deterioration of her mental health, there's nothing to be done about
My
Because
lord,
that's not what the expert is dealing with here.
no, yes, my lord. There is always going to be a risk to mental health. The question is, what is the likelihood of the risk, and how severe is that risk? How serious is that risk? And so perhaps one interpretation of 7.51 is that we cannot eliminate risk. Well, that's no surprise to anybody who sits in the family court. But what we don't really understand from the final few lines of that paragraph is whether Dr. McDermott is in fact talking about the serious risk of a significant clinical depression that she identifies earlier, or something lesser. We don't know, and that's another question that we would have benefited from hearing.
Sorry, can you say that again?
We don't know from that final line of 7.51.
Yes.
When Dr. McDermott talks about the virtually inevitable risk, whether she is talking about risk as an abstract concept, which of course is what the question asks. The question asks about any risk, not about any risk that you have identified in your answers to earlier questions. So we don't know whether she's talking about any generalised risk or the specific risk that she identifies at 7.3.1, which is a serious risk of developing clinical depression to a significant degree.
As my lord says, if one looks at the phraseology, how the question is phrased, and I think you've agreed with this, that what this is probably looking at is whether anything that can be done in advance to ameliorate the risks identified by the doctor consequent on a return.
My lord, I'm not sure it is limited to in advance, but I accept that there are further questions asked, and the next question, for instance, focuses more clearly on what would happen.
And if one's talking about the nature of the risk, the virtually inevitable risk, it would seem probably that she is referring back to 7.31, the risk that she's identified, rather than, because the question is phrased generally, because at that time when it was being drafted, nobody knew what risk she would have identified.
Yes.
Or she might identify. So it's asking her whether, having identified the risk as referred to in 7.3.1, are there any supports or treatment plans which could or might ameliorate that risk? I think it would be odd if the doctor was looking at it in terms of a generalised any risk, any other risk, because why would she be doing that?
Well, my lord, I don't disagree with that interpretation at all, but I'm cautious given that the main test of my case is that we really should have clarified these points with Dr.
I mean, your point is this question that could have been asked, but given that it wasn't, there are a couple of other indicators in this part of the report that might point in the same direction. First is that the first half of 7.5.1 is quite rightly, understandably, preoccupied with the problems that faced the mother in relation to her parents,
Yes.
and that those, of course, were not going to go away. Those were serious problems. The second thing is that we look further down point 7.5, and the expert, somewhat unusually, got quite stuck into the question of accommodation. We see a couple of times using AI to find out about what's going on in Queensland. It doesn't matter at all. But I mean that she wasn't there referring, as she does when you're going to come to it in a moment, to psychological and psychiatric services in Australia.
No.
That wasn't associated, that wasn't in her mind, it would seem, when she was answering this question, which is there anything that can be done to help with the problems and the consequences of the problems?
And in my submission, this question is really targeted towards the court's ability to undertake that risk assessment, whereas the question that follows, at question F, on one reading, is the court having decided to make a return order, perhaps implicitly, contrary to whatever you've said above, which is right, of course, judges make decisions, not experts, but the court having decided to make a return order, what then? What measures can we put in place? And it is in that section that you see then some detail about what would be required. Again, expressed in pretty stark terms for a single joint expert in this type of case. If you look at 7.62, crucial to have an intensification of sessions, and that's the final line of that paragraph. And we know that she's been seeing the same psychologist in Australia since October 24.
Is that on her work insurance?
Yes. And then plainly that's not enough, because at 7.64 there is the expert advice that the mother would need ready access to a psychiatrist, so of course a medical doctor as opposed to therapeutic support, and they should have a high index of suspicion for the development of a clinical depression.
Can you just explain that for my benefit? What's the index of suspicion?
My understanding is that refers to the diagnostic tools and things that they are alert to when assessing the mother. So a high index of suspicion for the development of clinical depression.
Very alert. Should be
waiting
very
for it.
alert.
Yeah.
Right, thank you.
Because again, as you'll see, I won't take to them now, but this mother has not previously had a diagnosis of clinical depression. It's adjustment disorder, two very, very different things. Adjustment disorder, short term, related to something that has happened, and the diagnostic criteria is there has to be a temporal link between the two. Clinical depression, very different kettle of fish. And then G, in a sense, a kind of drawing everything together question.
At the end of that, of the previous paragraph, 7.6.4, the psychiatrist says more likely than not that access to a psychiatrist would be available to her through her work, in my opinion. Do you know where that came from?
I don't, I'm afraid.
No.
There's certainly a general view that medical treatment in Australia is readily available.
No, but it was through her work.
Yeah, yes. No,
Is the yes.
I don't, I'm afraid.
Thank you.
So then if we move to G, really tying everything together, having been asked in a stepped and formulaic way to deal with the particular issues that the court is going to need to gather together and apply to its own risk assessment. The significant deterioration, the prognosis in terms of the significant deterioration would be high. Probably slightly convoluted way of putting it, but certainly on my reading, that's high risk of significant deterioration. So very much in line with what she says in answer to one of her earlier questions, although we have high here instead of serious. More likely than not, and you may have seen at an early stage of this report, Dr. McTermott sets out that more likely the balance of probabilities is the legal test. So we know that she's using that phrase with a particular, in a particular way. So more likely than not, the mother would suffer clinical depression of a significant degree. which, if persistent and unresponsive to psychological or psychiatric treatment, could result in a negative impact on her ability to parent. I think that the italicised could, certainly in relation to her answers to the letters, to the questions posed to her, is the only instance in which Dr. McDermott italicises anything in her report, and it suggests a significance attached to that word, but what that significance is, we don't know. Is it could, because that's something that really could happen, or is it could because it's a tentative view? We don't know. And there may, of course, be possibilities beyond that. So, having gone through that at some length, we say, and again, having, to fix this in time, having received this report 12 noon on Friday and being ready at trial Monday morning, single issue case in the sense that the only defence that's being run is 13B, no other oral evidence, even though both of the parents are present in London, 2 days of court time, a relative luxury, Dr. McDermott ready, available remotely to answer questions. She wasn't permitted to do so. Now, one of the authorities, and this is of course my first round of appeal, but one of the authorities you've been handed up by Mr. Gupta this morning is the decision of Malarkey. And I understand that his case is that in raising this issue in the way that we do, we are taking a new point that wasn't taken at first instance.
Before we embark on this, is the word permitted quite accurate? We read the note of the hearing and we see the way things went. Why do you say permitted?
That is, I think that is what I think Mr. Gupta means when he relies on this authority.
No, but I mean, what do you mean when you make the submission that she wasn't permitted? I mean, the question of whether she should give evidence was floated, but it, in the end, after some debate, wasn't pursued. So I just want to understand how you interpret it, because before you start off, what do you mean by wasn't permitted to give evidence?
So, my submission, so actually let me start this in a different direction. In the criminal division, there is an ethical duty upon barristers taking over new cases to undertake new inquiries. So to make inquiries with previous trial counsel and ensure that the factual basis upon which they advance grounds of appeal are, I think for want of a better word, accurate. They don't directly apply, I think, to this jurisdiction, but nonetheless are probably a helpful indication of the way that things ought to be done. And so prior to settling these grounds of appeal, I made inquiries with trial counsel, having received a copy of the attendance note from the father's solicitors. And her position is that she wanted the expert to give evidence and she didn't concede the expert not giving evidence. We've now seen two versions of the attendance notes prepared by the father's team. One version prepared by solicitors, the version prepared and referred to in the skeleton argument is in fact the father's counsel's document. The attendance note from my previous solicitors is not very helpful on this point because it's expressed in the summary terms that it is a list of an attempt at a transcript of the exchanges. The order that you have at 69, electronically and 67 paginated is a record of what happened at that hearing. And at paragraph 4, sorry, I'm pausing there actually, there is no requirement other than for the order itself, the return order itself, to be expressed in the order. There's no requirement for other decisions of the court to be placed on that order. It is a recital, yeah. But it is a recital that records that the mother made an oral application for Dr. McDermott to give evidence. that that application was refused. This order was prepared by the father's counsel. So that paragraph 4 was drafted by father's counsel and not amended by mother's counsel in the journey of the order as it travelled between the two advocates.
And approved by the judge.
And of course, yes, approved by the judge. You then have in your core bundle, final document you have an electronic 178. Sorry, electronic 180 paginated 178 is the PD 52C response to the application for permission. And this is the only document on this appeal that's authored by somebody who's involved in the case at first instance. So this is prepared by Mr. Fletcher, who represented the father. And you'll see that he deals with this issue under the heading refusal to call oral evidence from Dr. McDermott at 6, 7 and 8. And well, 8 I would say is the meat of it, carries on to 11. He doesn't say, as is now said on behalf of the father, that no application was pursued. His focus is on the difference, I think, between cross-examination and clarification. And I accept that no application was made to cross-examine, i.e. to challenge the evidence of Dr. McDermott. The paragraph 4, the recital I took you to before, is only, in my submission, explained by the fact that that's what everybody understood the judge had decided on the first day of this hearing. It's described in my learned friend skeleton argument as a typographical error. The whole recital is a typographical error, and that in my submission can't be right. So
well, we there are different ways of expressing this, different words. Your ground of appeal is that the judge was wrong to prevent the doctor from giving oral evidence.
I should stick with how I originally drafted it, my lord. Yes, I think that is the point. There were on any view, the fact that there were more questions to be asked of Dr. McDermott was raised at the early stage they probably could have been. And as a consequence of the exchanges between, or the net effect of the exchanges was that the Dr. McDermott did not give evidence. The court was left with the much less helpful position of hearing from the parents' counsel about their interpretation of that evidence, and and wasn't able then to properly draw out what it needed to draw out. It is accepted, clear from the appellate authorities and referenced in the judgment in this case, that the burden of proof in establishing the 13B defence rests on the mother's shoulders. And decisions about whether or not to call an expert have to be considered through that prism. If I can invite you to turn to the main authorities bundle and to the decision of the Supreme Court in the S. It starts at 155. The bit I'd like to take you to, if I may, is paragraph 26, which starts at 161 paginated, electronic. If we start a little bit of
Sorry, can you give me the page again?
161 paginated, my lord.
Yes, thank you.
So, similar situation, jointly instructed psychiatrist, Dr. Campers, written report, extracts of his evidence. Is similar actually in terms of the quantification of risk as we have in this case. So that's all it's set out at 25. And then at 26 there's an account of what happened at trial, and the Supreme Court notes, just a few lines from the bottom, Dr. Campus could have more clearly addressed the question that was asked for him. I suspect that's true of most expert reports eventually. Importantly, neither side asked him to clarify and told him that they didn't in fact have to attend the hearing. And the Supreme Court observes that that was tactical, probably on both parents' part, each understandably unhelpful, asking a clarificatory question. They would receive a response that did not help them, and so perhaps preferring to take up space in the ambiguity of it. Crucially, much riskier decision for the mother, because the burden of proof rests on her, in that case and in this one. What you see if we look at Mr. Justice Garrido's judgment, which starts at 72 electronic, 70 paginated bundle, doesn't actually set out Dr. McDermott's evidence as a standalone section. It's considered largely through the prism of each parent's case. When we reach the analysis section, which begins at paginated 80, electronic 82, Mr. Justice Garrido's first direction to himself is to remind himself that the burden rests squarely on the mother. He's right about that. He says then, 4 or 5 lines down, it's the mother to demonstrate the series of this risk and properly characterise as grave. And then if you continue on to the real core of his analysis on this issue, my suspicion appears at paragraph 47, the bottom of paginated 81, electronic 83. Describes Dr. McDermott's evidence as nuanced. He's accepted, it seems, the father's interpretation of her evidence thus. Considers it to be qualified, 5 or so lines down, and this reference to could, italicized could, amounts to a mere possibility, not a probability, of an impact on B in a limited combination of circumstances. But the final sentence is another bit tricky. The likely impact on B is remote. The judge's assessment of it, not anything that Dr. McDermott says, and not sufficiently evidenced. So the mother has not discharged the burden of proof, which, as the judge reminds himself, rests squarely on her shoulders. There must be an issue of fairness in those circumstances, because what the mother had tried to achieve on the first day of this hearing was to draw out, I think the phrase draw out is included in both versions of the attendance note, draw out issues as they related to B. And in the end, was not able to do so because the expert did not give evidence. So there was no she couldn't ask 25.10 questions, which she would have been entitled to ask as of right had the report come in sooner. And she couldn't ask the expert on the first day of the hearing. Not referred to my skeleton argument, but included within the authorities bundle, is the decision of the Supreme Court more recently in Griffiths and Toohey, which, although difficult, Griffiths and Toohey, it's at tab 17 of the authorities bundle, electronic 467. That's helpful to spend 5 minutes or so on this decision, because although very different jurisdiction, civil cases have experts instructed by parties, for parties, rather than the SJE approach that we take in the family court and the family division. And of course, the issue in that case was not about clarification, it was about cross-examination and putting a case to a witness. But even with those differences, if you look at Lord Hodges' judgment at paragraph 70, which appears 489, paginated 491 electronic, he sets out a number of propositions which can be derived from the authorities that he set out. And the two that I say apply in cases like this, where there's an issue about clarification rather than challenge, are at Roman numeral 5 and 6 on the top of the next page. So maintaining fairness includes enabling the judge to make a proper assessment of all of the evidence to achieve justice in the case, but the integrity of the court process. And then tips, cross-examinations, the witness the opportunity to explain or clarify. Not, of course, a warrant to cross-examine in all cases, but certainly if you then turn to the final page of this decision at paragraph 81, paginated 493, the final observations from Lord Hodge. About midway through the paragraph, he talks about the proportionate use of resources as being a very low value claim, and the provision for defendants to ask focus, CPR 35.6 questions, which is the equivalent of our 25.10 written questions for the purposes of clarification. So that is always, in my submission, the first step, and it is not unusual to see a direction in a Hague case that says that an expert report will come in, 2510 questions will be asked, and at the PTR there'll be a decision on when they give oral evidence. Reasonably common in my experience. So you don't end up unnecessarily having an expert give evidence and take up full time in doing so. But you've got to ask. And the reason you've got to ask is not procedural actually. It's fundamental to the judge's task. The expert's role is to give the judge evidence, clinical evidence, that neither of the parties can give to the judge, and to present that evidence, certainly in family proceedings, in a neutral, by which I mean, non-partisan way, as a single joint expert. The court, having already concluded at an early stage of these proceedings that this assessment was necessary, the judge needed to be able to understand the full extent of the expert's evidence so that he could properly discharge his function in undertaking the risk assessment that he had to take to evaluate and determine the mother's Article 13B defence. There is no dispute between us, nor could there possibly be really, about the task that the judge had to undertake. It's in my Lord Justice Moylan's decision of a re-B at the authorities bundle electronic 540. Paragraph 54. Sorry, the heading page 538.
Sorry, hold on. Which page?
538.
Which paragraph?
54. The key question. So it's the critical question as identified in RIAS, transposed into a risk assessment, which is a version of, it seems, earlier risk assessments identified by my Lord Justice Peter Jackson in RIAF and developed, I think, most recently in RET. So three-part, not very laborious or complicated in my submission, and now certainly standard practice in the family division. We've got to consider the nature of the risk, the likelihood of it materialising, and the consequences for the child. That third bit is the only bit that really deals with the intolerability and grave harm exception, because it's the only bit that's totally focused on the child. But in order to get to that bit, you have to first understand what the nature of the risk is and the likelihood of it materialising. And there have been quite a few appeals to this court on this particular species of Article 13B defence over recent years. And it's now very clear in my submission that this is the approach, and that the court needs to be really careful about the evidence that it receives from the instructed expert about the difference between nature, the nature of the deterioration, and the likelihood. And there have been issues before with confusion about what, for instance, which bit of it needs to be serious and which bit of it needs to be significant. So you've got to be really careful about the expert evidence that you have. And the expert evidence is, of course, the basis upon which you reach your conclusions. And that task is not, in my submission, properly undertaken by the judge at any stage. I mean, if we go back to his judgment, again, as I've set out, perhaps if we start at core bundle, paginated 75, electronic 77.
We can put away the authorities. Yeah, thank you. Sorry, I'm the only one with paper. Yes.
I'm sorry, I think I should start with the law actually quite quickly, having addressed you on what the legal approach is. But it's at page 73 of the judgment, paginated 73, electronic 75. The only actual decision that's referred to is the decision of the Supreme Court in Reading. Although I think, in fairness, the second sentence of paragraph 19 is quite obviously a reference to RIAS, even if RIAS is not explicitly referred to. But there's no at paragraph 20 there's relevance to effectively the confident discount. And then 21 is really just a reflection of the approach to 13B generally, you look at the risk and then you look at the protective measures. It's not at no point here does Mr. Justice Guido identify the paragraph 54 of Re-B that we just looked at. We then see, as I set up before, slightly unusually, we don't have separate section on evidence. We have submissions as advanced by the mother, so the mother's case, and then a couple of pages later, the father's case. And actually, at the very conclusion of that section, that's where you see the conclusion, the end point really to the father's submission about depression, which is referred to in his skeleton argument as prepared for trial. The mother has responded well to treatment for depression in the past. So that error has made its way from the skeleton argument and now infected the judgment. Again, slightly unusually, consideration of protective measures before we get on to analysis. And I say consideration because it's not just sets out really some analysis and conclusions on protective measures beyond just summarising what it is that each party offers or requests. And then when we get to the analysis, there is at 46 in the context of an issue that we say became slightly confused over the course of this trial about what role the mother's parent vulnerabilities play in this case. Not, of course, an independent, not people with whom the court is independently considering the best interests of or anything like that, very different. Quite properly, the judge says to himself, and I consider the impact on B of the likely consequences for the mother's mental health if B's return is ordered. That's not quite the three-stage process. It is really, if anything, the third stage. And so having posed that question in paragraph 46, the judge comes on to answer it, but doesn't answer it in any structured way. And in those few lines having set out really only Dr. McDermott's answer to the very last question in her letter of instruction. In relation to what he described as a qualification of the doctor's evidence. That is, there's an obvious nexus between what the judge says in that sentence, she qualifies her opinion, and the decision that he makes in the next sentence. In my judgment, that amounts to a mere possibility, not a probability of an impact. So all we understand from that sentence is that the judge has assessed the probability to be a low one. There's nothing in there really about the nature of the deterioration. And as we know and is well established, when you're looking at grave harm, a low risk of a much more serious harm, like death, for instance, is far more likely to engage Article 13B than a higher risk of a much lower harm, and that's of course Baroness Hale. And then we're back to one of the points I made earlier. Really, what the judge doesn't do is say, or arguably doesn't do, is say, I suppose the equivalent of a confident discount on a risk to be if there's any deterioration in the mother's mental health. But actually his decision is based on an insufficiently evidenced conclusion. He's not reached.
I was just looking to see what the submissions to the judge were on these questions, and if we could just look very briefly at the supplementary bundle. And at written page 3, page 5, we have the submissions on the law made by the father, who refers the court to E and S, and then further down to another case of A about discounting possibilities. So that was the selection that the father presented.
Yes.
We then go to paper 21. We have, over the course of quite a long passage, some 7 or 8 pages of law, put forward by your predecessor, which you can see obviously a large number of cases cited for various propositions, but not as I think, including the case that you've just referred us to, re-B. So
It was detected perhaps elsewhere that an additional list of authorities was sent in by the Father's Council, and I understand they were another series of first instance decisions of the High Court.
well, there were a lot one can see that it was just a travelogue of what had happened in other cases. But I mean, it just when we're considering the position that the judge was in, he's taken to know how to assess risk in these matters. But as I may have missed it, but my brief search of those skeleton arguments
Well, would you have
doesn't show up that particular authority.
He was entitled to much better assistance as to the proper legal framework that was engaged, and he didn't.
Well, there are two possibilities, aren't there? I mean, first you can say he was entitled to better assistance. The second is that the judge is taken to know how it approaches the question of risk. Consider all those possibilities.
The difficult. I mean, he was taken to a number of first instance authorities that deal with that would certainly put before him on the basis that they dealt with similar facts and similar issues, and to various degrees they referred to the proper task before the court in doing this risk assessment. It's not. This is not now an unusual part of a 1980 Hague Convention application. There is an increasing number of applications for psychiatric evidence. There are, if you do the survey of the reported decisions that is set out in the Mother's Council skeleton argument, an increasing number of decisions, first instance and on appeal. So I would be the first to accept that this judge should have had a clearer signpost to re-B, if nothing else. But he had, by way of the father's skeleton argument in any event, re-X, which identifies what the critical question is, and the fact, and he had, through the prism of these first instance authorities, which I accept is far from the best way of putting this issue before him, an analysis of what the risk assessment needed to be, and he didn't do it. And that was fundamentally the task that the judge needed to do.
Just ask this. There seem to me to be two different questions. The first is the likelihood of the mother developing significant clinical depression. The second is what the impact on B would be of that. To what extent was Dr. McDermott competent in relation to the second question? Because there's not something I think she addresses other than the word could.
My lord, it's very difficult actually for an expert, a consultant adult psychiatrist, to who will never, of course, have met B as part of their assessment in any event, and whose only knowledge of B will come through the prism of the parents' statements, which, because of this, the summary nature of the Hague Convention and the way in which it operates, don't traditionally include a lot of material about welfare elements that we might see in other types of proceedings. What expert evidence on this issue normally looks like is a comment on what a decline in the mother's presentation would look like. So impact on their day-to-day functioning, their sleep, their ability to meet a child's needs, to care for another person. So they can comment on how, to a greater or lesser extent, the parent is impacted. And then the task for the judge is to analyse that impact, so the deterioration and the manifestation really of the deterioration, and to analyse that impact on the particular child that they are faced with.
Right, so you wouldn't be asking further questions of the expert directed to that second question, which is for the judge. The expert can only take you so far in determining the likely impact on the mother's mental state.
I think we would ask, when the expert says this could impact on parenting, that's of course a very a global view of it, I suppose. Certainly an understanding of what that meant for the mother's parenting and what that looked like in particular, that should have been drawn out. But
on that aspect, you've got the Dr. McDermott's evidence that there's a serious risk of developing a significant degree of clinical depression if forced return to Australia occurs. But then her conclusion is that could impact on B
yes,
if the mother does not obtain treatment or is not responsive to that treatment.
yes.
On those questions, the judge said there's no evidence that the mother would either not be able to access treatment or would be unresponsive to it. Was the judge right in that comment?
Respectfully, no. We can start just negative consequences to her emotional availability to and responsiveness to Billy. Well, that is a question of degree. There is a certain amount of perhaps lack of emotional availability and responsiveness that may well not meet the threshold of intolerability for purposes of Article 13b, but there will be, depending on the extent to it, the extent of it, quite capable of reaching that threshold, or depending on the particular facts of the case. The difficulty in my submission with the way that the judge deals with the protective measures, which he deals with in this paragraph, he describes it as no evidence to establish that the mother would be unresponsive to treatment or unable to obtain treatment, is in my submission the wrong way round, because that's really a question of protective, those are questions of protective measures. their answers that we received from Dr. Dermot in the question of a protective measure. And so once, the two-stage process of Article 13b generally is to establish whether there's a grave risk, number one, and then to look at whether the protective measures are sufficient to ameliorate that risk. And that's where the requirement to focus on the concrete situation for the child comes in.
I'm not quite understanding this. That as you say, it's for your client to have proved the exception under Article 13b, and that in this case is involved establishing that a return order would have a very severe impact on her own health, which, and this is the point we're touching on at the moment, which could not be ameliorated, and in consequence there would be an intolerable situation for B. As I understand how this works, all of these things are for the respondent to one of these applications to prove. It's not a case in which the burden shifts to the other parent, and in order to establish that there would be healthcare, for example, it's for the parent who says my situation will be so bad that the impact on the child will be intolerable, to establish all of that. Is it not?
Well, my lord, I think if we turn up the authorities bundle and we
Well,
look at...
do you mind answering the question first, and then evidencing why you say so?
Yes, not quite, because the whole purpose of looking at, got to be able to establish the 13b threshold, that burden rests squarely on the mother's shoulders. But when the court goes on to look at what the protective measures are and whether they are effective to deal with the 13b defence that's been established or the threshold that's been reached, the court's concerned with whether or not those protective measures are effective, not whether or not the respondent has proved that they are ineffective. And that, my lord, I get from Mr. Justice Coventry, then was now the president, in his decision of Re-T, which is in the authorities bundle at 509 electronic 511, sorry, 511 electronic 509 paginated. And this was a case, it was really about soft landing provisions rather than more fundamental protective measures. But point 3 requires the court to be satisfied that the protective measures are going to be sufficiently effective to address the Article 13b risks. So there is a positive requirement for the court to be satisfied that they're going to be effective, not an obligation on the respondent to prove that they are ineffective. In this case, the judge relies on the general principle of comity, and an expectation that things will be available in Australia, psychiatrists, for instance. Given what Dr. McDermott says about ready access to a psychiatrist, this is a case where, in our submission, there needed to be a proper understanding of what support the mother was going to get immediately on return. And this is the concrete situation point, really. When the mother and V stepped off the plane, was she going to be on a waiting list for a psychiatrist for 6 weeks? If so, what was going to happen in the interim? Would that be manageable? Was there somebody ready and raring to go to treat her? The court needed to be satisfied of the reality of the situation in order to determine that it was going to be that it was a protective measure that was effective. In fact, there's nothing in the protective measures about access to a psychiatrist other than an agreement by the father that the mother could use his work insurance if she wanted to, but nobody suggests that he can actually, that she could actually access a psychiatrist, a medical doctor through that insurance. So, developing that point really in RET, if you turn to paginated 511, electronic 513. This is the development of that point. Protective measures need to be effective measures. And I think that's really a summary of what I've just set out. Like I said, in this case, although the case on protective measures is directed to a different series of issues, it's about the enforceability of largely financial provisions in the USA, which, as you all know, is not a 96A convention country. So if you look at the points that are developed below about foreign law, they obviously only apply in that particular context. But in this case, in light of Dr. McDermott's report and of course the conclusion that the judge reached, that there was a mere possibility, not a probability, and it would be in a limited combination of circumstances, and that there was no evidence to establish that the mother would be unresponsive to treatment, not unable to obtain treatment. Difficult to see how that meets the risk identified, because nobody's identified the treatment. And I would accept that it would be difficult to in some cases where there's a long history of mental health, a long forensic history of mental health difficulties, a court might be able to say that she would be responsive to treatment, or we can't be confident that she would be responsive to treatment. That's slightly more difficult in this case, I would accept. But the analysis on this is, I think, the wrong way round. It's not about proving that you can't access treatment. It's about the court being satisfied that the protective measures are effective. And that's why, of course, standing back from this, there's an obligation on both parties to set out the protective measures that they offer and that they request at the earliest stage possible, and for that to be kept under review as the proceedings unfold, because the court needs to understand what can actually be put in place, and that's a joint endeavour in my submission.
What was your client's evidence about her ability to obtain, to use the doctor's word, access to a psychiatrist on return?
She hadn't filed any evidence on that particular point, but it was a feature of the hearing. I think it was said that it was unlikely that she was going to be able to access a psychiatrist through work. That was a submission that was made on her behalf. To address what the doctor had said in her report about she would be able to. Yes, that's my understanding. My lord, I'll ask that question of my client and give you a fuller and better answer to that.
Yes.
It's recorded in the judgment at paragraph 40.
sorry, in,
In the judgment,
yes,
the judge proceeded on the basis, if you look at the very bottom of paginated 79 and 122,
yes,
I have received some evidence the psychiatrist may not be available through her employment or father's employment healthcare schemes. I think that's a reference to submissions he heard on the day, but I'll double check that.
yes.
One option open to him, of course, at this stage, and this is the really GP point that I refer to my skeleton argument, is that he could have said, well, I need to understand more about what can be put in place for the mother on return in light of Dr. McDermott's evidence, which has come in so recently. And so I'm going to require everybody to set that out and have a short adjournment, and you can come back to me on that point. That would have been a way of flushing out this issue. Perhaps whilst we're on protective measures in a general sense, I can deal with. I think I've comfortably dealt with the first few grounds of appeal, say as they relate to domestic abuse, which I'll deal with separately if I may. Is it convenient for me now to deal with the final ground of appeal, which relates to protective measures?
Entirely up to you.
If I can do that, then having taken you to read tea, can I take you in a core bundle to the final order, which sets out the protective measures at 69, it's 71, paginated 69.
Yes,
So there are two undertakings given by the father. And then everything else is set out under the heading of agreements.
yes,
I think I've highlighted in my skeleton that at the moment there's a difference of opinion in the High Court about whether non-molestation undertakings properly come within the 96 Hague Convention, but I don't, given the other issues that are raised in this case, I don't take a point on that, but I'm highlighting the dispute.
can you remind me where you deal with that in your skeleton?
Yes, it's paginated 30, electronic 32.
Yes,
It's a footnote.
oh, it's a footnote,
It
yes,
really is dealt with in passing. But there are competing decisions of Mr. Justice MacDonald and Mr. Justice Williams about whether or not a non-molestation undertaking falls within the parameters of the 96 Hague Convention.
and what's Mr. Justice Williams's case?
It's referred to in N and N, but
Do we have any?
We don't have it,
Okay.
but I can send them both over.
And Mr. Justice MacDonald said there's a question as to whether non-molestation undertakings fall within the scope of the 96 Convention, is that right?
Well, Mr. Justice Williams says they do, and
Yes.
Mr. Justice MacDonald said they do not.
Yes,
And that is, I think, the current position as to the difference in the High Court. I don't think there's been any cases on it since, but I can check that.
don't worry, thank you.
core bundle, then conventionally we've got these sort of undertakings and undertakings common feature in Hague cases. Some disquiet expressed about them in relation to particular jurisdictions, because we know that Australia is a Commonwealth country. Generally, people are quite confident about the ability of undertakings to be enforced there. As a general one, I think we've got a decision of Mr. Gupta handed up earlier of Mr. Justice Cobb, as he then was in another Australian case. And I think Mr. Gupta relies on this that point. I'll let him get through it.
Right.
Curious then that in light of the Article 13 being this, and the kind of the core of the mother's case, everything else is just recorded as an agreement, not binding in England and Wales, let alone Australia. An agreement not to remove the child from the mother's care, that might not be of massive consequence in another case. But Dr. McDermott was very clear about the impact on the mother's mental health if there was, in effect, forced separation. I think her exact words were major collapse.
It would be quite difficult for the fathers just abruptly to remove the child from mother's care without the court becoming rather rapidly involved in Australia, isn't it?
Well, it might be, but it's on the standard standard template orders issued by Mr. Justice Peel. The standard 1980 Hague Convention provision in relation to non-separation is an undertaking.
The difficulty for you on this point is surely that this was not an issue for the judge. This was what the fallback position was if an order was made. And in any case, I'm not quite sure what the evidential foundation in this case would be for needing more. Not one of those sort of cases.
Well, my lord, it's as relevant to the impact on the mother's mental health.
Yes, I know, but there's a limit even when you come in as new counsel, to the extent that you can start taking all sorts of points that weren't taken below. Still more if they were agreed.
I will focus then, if I may, on the point about the psychiatrist, because the most you see about any protective measures in relation to a psychiatrist is paragraph E. And I think we can see from the father's response to the mother's fresh evidence in this case, there isn't really any psychiatric support available. I think the reference to it in that statement is limited to psychological support that would be accessible by her. Capable of being accessed by her.
And just before we lose touch with the point, the decision of Mr. Justice Williams was in a case called A, Hague, Article 13B, Protective Measures, 2019 EWHC 649 FAM. 2019 EWHC 649 FAM.
I think we can get copies of both of those.
But that's all right. Thank you.
And he said, as recorded by Mr. Justice MacDonald, is that they may qualify as a measure for protection under Article 11. So that's how that was summarised.
Shall I deal finally then pause to any questions others have with the round 2A. Round 2A is in the and they say something more about round 2C as it relates to it. The domestic abuse allegations in this case required to be considered alongside and cumulatively with the issues of psychiatric harm. They weren't, and nor should they be in any Hague Convention case, a standalone strand that can be separated, put to one side, dealt with separately. The central importance of the allegations that the mother made about the father's behaviour was not really the type of behaviour that is caught or managed by injunctive relief. It is the type of behaviour that is described in REHN as post-separation coercive control, behaviour that, or abusive behaviour that manifests itself in some other more insidious way post-separation designed to retain control over a person. And so the allegations in this case were really about the father's conduct, about how he had behaved in a punitive way as alleged by the mother, but crucially the impact on the mother of her perception of all of that. Because on any view, she was going to be dependent on the father for something, at least one very important thing when she returned, and that was permission to be able to come back and see her ailing parents with B. And she set out in her statement how, in her statements as prepared at first instance, how she experienced the father's requests for these returns being linked to issues that she had raised with him about finances or similar, so she saw them as punitive and targeted. You can see that at paragraph 30, at page 100 of the full bundle, paragraph 31, excuse me, paginated 98. Unfortunately, we don't have all of the exhibits to the mother's statement. We brought hard copies if you'd like to see them. In fact, you get a sense from the mother's fresh evidence application of she would describe as the father's punitive and controlling behaviour in her account of what happened when the decision for permission to appeal was granted. She wasn't able to contact him for the purposes of the calls that he had been enjoying 4 or 5 times a week for a couple of weeks. It seemed he blocked her on the application they usually used. So that's really where the mother's case on domestic abuse fell to be considered in the context of the psychiatric evidence that the court had. And if you look at how the judge deals with it, really at paragraph 45 of his judgment, electronic 83, paginated 81. Says there's been a significant passage of time since the breakdown of the relationship. I don't think that's right on either parent's account of what happened. And there's been no complaint about the father's conduct, and that obviously doesn't match up with what the mother says in her statement. In my submission, relatively few cases are solved by parents not having to live together and not having to come into direct contact because of the issues about post-separation abuse.
Where was this, if it was, issue addressed in Dr. McDermott's report? In other words, where did she ascribe significance to those matters, or is it your client's evidence?
My client's evidence. So in my submission, that required to be dealt with as a whole, and certainly the only element of it that Dr. McDermott really deals with is that this idea of a separation between a separation of B from his mother. You see that at her evidence, her report 7.42, page 138. Electronic 138, paginated 136. If there was an enforced separation, then that would result in major mental collapse. And one of the mother's concerns, based on her experiences, was that is something the father would do. Certainly that he would contrive circumstances so that they would be separated, and she would be placed in a position of not being able to come back, or if she was to come back, having to leave me at home. So really that required to be considered alongside the psychiatric harm case, and cumulatively, as is clear from the authorities. My final few words then, if I may, is just going to be a short point about the way that the judge dealt with the issue relating to the mother's parents, because this was not a case. There could be a case about whether whose needs trumped each other, the maternal grandparents or B's. The relevance of the mother's parents' ill health was limited entirely to the impact on her of having to leave them, and that is set out, the impact of that is set out in clear terms in Dr. McDermott's evidence. In the judgment, the focus of that issue, largely is ventilated in the context of, I suppose, the mother not having to, the mother being able to leave because there will be appropriate care here, and that's not with respect. The point was the mother's anxieties, subjective anxieties, which we know from the ESA are as valid, as relevant as objective and reasonable concerns. We know that they are part of the analysis, and it's very difficult to see. There's actually it's one of the issues that occupies quite a significant amount of the judgment. It's not putting my submission in the right place. I deal with that in my skeleton argument in any event, so I don't propose to say much more on it. My lords, is there anything else that I can assist you on? I think I'm slightly over
Don't worry at all.
the time I said I would be.
No. Thank you very much. Thank you. Yes, Mr. Gupta.
Yes, Your Lordships. I, together with my learned junior, Mr. Wood, represent the respondent father, of course, in this matter. And I'm sure he'd like me to say at the outset he's joining by way of the link. I'm sure you'd like to say at the outset how much sympathy he has for the mother's position and has had throughout, and hopefully that's apparent from the messages that you'll have read in the bundles as to how this situation has developed over time. What's happened, of course, is that they were a couple when she left and came to England. And what you'll see in the documentation is most regrettably a disintegration of that relationship. And that is a reality, of course, of family cases before the family division, indeed, and of course, in this court. The advantage that I have is that Miss Wood, and indeed one of the instructor solicitors seated behind me, were actually there at court on the day of the trial. And so the note that has been referred to as different, but it's the same note. One note from Moylan Jr., who was there pro bono, just there to take a view, watched a Hague Convention case taking place, and my instructing solicitor is effectively the same. So what we put in our skeleton submissions that you'll see with regards to what took place on that day, and indeed the note, which you'll see in the supplemental bundle. I'm afraid I'm going to go by way of electronic page references, but of course just take away two pages from that number, 288. At the bottom, that phrase, don't seek to pursue or don't pursue, is what Moylan Jr. had a recollection and a note of, and what my instructing solicitor had a recollection and a note of. That actually what was being put, because of course the expert was available, was actually warned to attend. And so if there had been any questions, it would have no doubt resulted in no inconvenience to the court, because they could have been put forward pithily and in a focused way to the expert, and it wouldn't have resulted in an adjournment, because that's why over the page at 289 you'll see learned counsel, junior counsel on behalf of the mother, asking whether she could take a moment to email Dr. McDermott and tell her that she was stood down.
I mean, if you go a bit higher up on page 3, the judge says that he thinks he can manage without hearing from the psychiatrist. And then counsel makes a number of submissions about where it might help. And he said, I think I can do both those points without hearing. And of course we have the order that says an application was made and refused.
Yes, all I can say is that it must surely be a typographical error that wasn't spotted.
It can hardly be a
But there
typographical.
it
I mean,
is.
it's not a typographical. I mean, I think saying typographical, it either reflects what the judge thought he had done, or it doesn't reflect what the judge thought he had done.
Well, if we look at the transcript, it doesn't reflect the order. He hasn't refused any application. There would, in my submission, be a judgment. There would be a short ruling as to why he doesn't regard that person as necessary, and why the court shouldn't accede to counsel's application to cross-examine that expert. And looking at the skeleton submissions on behalf of in the court below, on behalf of the mother, supplemental bundle 21 onwards, Your Lordship, Lord Justice Jackson referred to the authorities that were not cited and some that were. But I was looking for questions for the expert, because of course, when an expert is coming to court or being made available, the question is, paragraph 14, electronic page 23, what's going to be asked of this expert? Dr. McDermott has been warned to be available remotely. Limited evidence from Dr. McDermott may be of assistance to the court in light of the contents of the report. It doesn't say, and these are the issues that we'd like to put to this expert.
The skeleton's dated the 27th. The expert report was dated.
The 24th. I think it's one counsel for the father's document is dated the Sunday, and one counsel for the mother was presented on the Monday,
Yes.
so they were not even dry.
But that's the collective understanding of what happened at court on that day, and that the order, with great respect to those that drafted it, and indeed the learned trial judge, doesn't reflect the reality of what took place. But if we put that to one side, one of the issues could be, of course, well, what questions could have been asked? Could they have been drilled down to an extent? What you see at paragraph 14 in Marston's motion is an acceptance, of course, of the report, and really putting it over to the learned judge in his inquisitorial capacity, in an adversarial situation, in a summary process. I hasten to add that, which of course he mentions on a couple of occasions, to see whether or not there's anything else that he needs. And he says, well, I don't actually need anything from this expert. But we couldn't see any ruling, as I'm repeating myself, or any decision that's summarised in notes or anything like that, whether that, when it was put to the learned judge, I seek to cross-examine this person, here are the questions I'd like to put, or some in writing. It could be adjourned for half an hour while the learned expert decides what her response would be to those questions, but nothing like that. And while I'm on this document,
So are we still on
skeleton argument of the model,
page 21 or page 23?
20, yes.
Yes. I mean, I'm just looking at the, just to get a sense of where everybody was. Paragraphs, not just 14, which you've just taken to sort, but
Yes.
also paragraph 13, one sees that a very distressing diagnosis
Yes.
was learned about on the Friday. So that was on top of everything that was going on in the case.
Absolutely. Absolutely. You've mentioned, your lordship mentioned about the authorities that were placed before his lordship. Really the key one that's been mentioned on a number of occasions, if you look at paragraph 18 on electronic page 25, the bottom is of course re-E, and then touches on the other Supreme Court authority, re-S, but you'll see at paragraph 37 on electronic page 31, she relies on the report as it is. Paragraph 37, taking the risk harm at its highest and it's submitted to the psychiatric report document unequivocally sets out the risk, consequently the care, and doesn't seem to want to depart from that or ask for further inquiry. While I was looking at this document, I have to ask the court to look also at paragraph 44, which ends with a strange sentence, if I can invite the court to read paragraph 44, electronic page 32. In other words, well, my client's case is it is available. He mentions it in his undertakings that he's offered to the court. That's in the original undertakings that he offered, which you can find at page 152, 153, electronic page 153 in the bundle, which is dated 30th of March.
Sorry, which?
I beg your pardon, supplemental bundle 153, printed page 151. I undertake to provide all the support available, Department of Veterans Affairs in relation to funded psychological and psychiatric services as available to her as an ex-partner of a defence member. Obviously one's not sure about the status of these extra documents that have been placed before the Court of Appeal, the mother's application to deduce further evidence, the father's evidence in response. But if they are allowed in, then page 3 336 at the top of the supplemental bundle has further information about that fact, and indeed a hyperlink. But for the mother to say, well, even if it was available, I wouldn't take it up, in Morrison's submission speaks volumes. Of course, the medical care that she's getting right now is from Australia, and it has always been from Australia, from the psychologist who's provided evidence in this case in the past. And so she's not accessed, as far as one can see, any medical care for herself in England.
I thought the judge's conclusion, if you're dealing with psychiatrists, in paragraph 40, was that he put it, some evidence that psychiatrists may not be available.
Yes.
I thought it was accepted that therapy or psychologists would be available, psychiatrists wouldn't be.
That's my client's evidence, if you see it in writing in the undertaking, is that there may be psychiatric available.
Well, if available, but there's not. That's very different from saying it is.
Yes, but go back to what Lord Justice Jackson said. Surely it's the burdens on the respondent in the Hague proceedings to show that things are not available. And what you see there about that paragraph further down, and it's not been seriously suggested that Australia lacks appropriate services.
That's a different
To
point.
treat
I was just
depression.
dealing with the point you're dealing with now,
Yes,
which is you seem to be suggesting that psychiatric assistance would be provided through the father's employment, and I don't see evidence to that effect.
well, the evidence is, as what I've referred to, the undertaking that he mentions that.
Yes.
Go back to what he actually says, if it helps at all, I don't know.
Well, it says where available.
Yes,
Doesn't-
The note, we need
As
to
is
go back
available.
to it, but the note we were looking at before, the note of the hearing to 286, but I can just read out what it said. The judge said unavailability of services through employer, not unavailability of services. So
yes,
the judge was alive to the distinction between where any services were coming from, and he appears to have fallen back on the fact that generally there are services.
Yes.
yes. And so that's all I wanted to say with regards to the skeleton submissions that were filed on behalf of the mother, because we were looking at that document just so that you can move away from the
Right.
skeleton submissions that were made in the court below.
Thank you.
And of course, one can always have counsel of perfection in 2020 hindsight. What could have been run, what couldn't have been run. But the learned judge, looking at his judgment, looking at paragraph 22 of his judgment, electronic page 77, says boldly, that's all I need to say about the legal principles that I apply in this case. Now, what he hasn't done, which is what I think it was Mr. Justice Mostyn referred to once when I asked him for further elucidation of his decision, was pre-flight, what he referred to as pre-flight checks. He didn't, in his judgment, go through all the authorities that were cited. And again, a word that Mr. Justice Mostyn slavishly set it all out. And of course, this has to be remembered that the context is of this document. This is a note of the learned judge's judgment. And what happens, as the court knows full well, is that if a transcript is obtained, then the learned judge can add to that judgment, not change the decision, of course, but can then say,
I thought the judge had worked on this note
Right, it's
to
approved.
whatever extent.
yeah, he's looked at the note and approved the note.
Yeah. So that if you wanted to adjust anything, that was not his opportunity
That
to
was
do so.
indeed his opportunity, yes.
Yes.
But what he hasn't done is set out all the authorities that were raised in submissions. But of course, in my submission, he mentioned the main one, which is RE, and he talks about the principles that he draws from that. The context, again, of this decision is a one-day hearing, summary decision on the papers, and that's what I'd ask the court to bear in mind when he's looking at whether this summary process allows for anything further than a comprehensive, as far as he can do, assessment of the mother's case, her defence under 13B, and whether or not it reaches the requisite standard, which of course he decides that he doesn't.
You mentioned 1 day hearing. It had been set down for 2 days, and what seems to have happened is that the judge heard submissions until 2:30 on the Monday, and then he adjourned, until not before 11:30 on the Tuesday. So that's how the hearing went, as I understand.
Yes. And no doubt he had in his mind the overriding principle and the fact that he has other judicial work to attend to, and no doubt has a busy diary and can allotted the time for this judgment, knowing that full well that any time that he saves in this matter could be allotted to other cases. And can I say that I've read a longer judgment? Yes, I have. A longer note of a judgment, summarising the authorities in a more detailed way, summarising authorities that maybe council doesn't mention, but that are relevant, such as Re-B, for example, which was mentioned earlier on and we'll turn to in a moment. But that doesn't detract, in my submission, from his decision not being wrong, if I can put it that way, as we are here in the Court of Appeal. That a different counsel and a different judge on a different day may have come up with different submissions and different judgment, but that's not, of course, the test that the court has to adopt. And you'll see that the skeleton submissions on behalf of the respondent, which I should have mentioned at the outset, and all the hard work that Moylan Jr., Miss Wood, has put into them, with some hard work from me, page 40, electronic page 40 of the bundle, and we pray those in aid of our respectful submissions. The only defence is this Article 13b defence, and the mother finds herself in obviously a terrible situation, which has got worse to a certain extent in that her father has passed away, but in practical terms has meant that there are a number of things that could be done. Turning back to the learned judge's summary of the law, I haven't heard that I haven't read or heard anything that says that the learned judge misdirected himself or that the principles that he set out were wrong in any way. The question is, did he apply those principles? And we respect that there's enough there to show that indeed he did, but also dealing with the material that was in front of him, the decision not to ask for, I'm pausing here, but not to ask to cross-examine the expert. Whatever the order may say, we respect that it should be amended under the slip rule. But in any event, the lack of further inquiry, and indeed the lack of further inquiry from counsel, because of course it's always open to counsel to request clarification on certain points if something doesn't seem to be appropriate or properly set out. When it comes to, and I'm sorry I'm jumping around here, but if we come and look at protective measures that were actually being asked for, the court will see at electronic page 105 of the core bundle, the protective measures that the mother was asking for. And they're pretty much all agreed to by the father. I've already given you the page reference for the father's offer of undertakings, which are at page 152, electronic page reference 152 of the electronic bundle. But also going back to the undertakings, the mother then filed a further statement on the 13th of March, which is at supplemental bundle 93, paragraph 14 onwards. I've already set out the protective measures I require.
That all predates the medical evidence.
Yes, indeed. Indeed it does.
Doesn't it?
But then after the decision is made, of course, it's incumbent upon counsel to set out what is required, and that's where we turn to the draft order, which we respectfully submit, as I've set out already, is flawed. But in any event, there were no long submissions, written or otherwise, as to what undertakings need to be put in place, what orders need to be put in place, and they were simply drafted by counsel for the father and agreed to. It seems I've seen an email with one tweak, the draft order, that is, including undertakings on behalf of the mother. She wasn't asking for anything further, and that's what the learned judge is presented with. If he's presented with that, then how much further inquiry does he need to do? Of course, he should have corrected or asked for further analysis of recital 4, and I can't depart from that. But in any event, if nothing further is being asked for on behalf of the mother, what can the learned judge, or indeed the father, do in that situation? And no doubt the mother will we respect it can and will make arrangements. What she was telling the courts, of course, in her first statement, was...
Do you want us to go to that?
Yes, if I just turn to that now. Page 98, electronic page 98, obviously printed page 96 of the core bundle. Bottom of the previous page. If I was to turn back to Australia, the reality is I do not have anywhere I can live. And I certainly don't feel that I can, certainly do not feel that I can return back to the home and stay with the applicant. She repeats that, that paragraph 43 on electronic page 103. I would have no option but to return with him. I would have nowhere to live in Australia. Currently do not have accommodation. It's only when the father refers to the court in the supplemental bundle at page 145, electronic page number, that one of her houses is not far from their home on the Gold Coast. That's paragraph 37. That the tenor of her evidence change. He produces the tenancy agreements, which is at page 198 of the supplemental bundle.
Sorry, what was the previous page you referred to?
Previous page number is 145, paragraph 37. And that tenant, which you'll see, is Miss C at 198, initial CC, is the same current tenant of the property, and that's obviously rented out for a while. So, and then the latest evidence, if the court allows it in, de bene essay or otherwise, paragraph 18, page 317 electronic, she then eventually says, well, yes, I will get my tenant to move out. Putting credibility to one side, in my submission, this is an example of not thinking through, and hyperbole, not thinking through the practical arrangements that could easily be put in place by the mother if she's put in the situation which she seems to be in, of having to make a decision. And the decision is, does she stay to arrange the care of her mother, or does she return with her child? And her child, of course, is being deprived of the care, as well as society, of his father. And my client's position, as you've seen, is that he's ready, willing and able to take over the care of the child and return with the child, if necessary, even if it's for a while the mother sorts out her arrangements. The court can't be blind, and indeed the judge in the court below was not blind to the realities of the mother's situation, which is why he ordered a slightly delayed return. Normally returns are ordered within, some returns, as the court will know, within 14, 21 days maximum. Actually, this is allowed, she's been allowed 2 months. And of course, she came here to England all those months ago to organise the care of her parents, of her mother, really, because her father was under difficult circumstances. The reason why I'm mentioning all these things, because of course one has to look at them, sorry to use that word, holistically at the defences. The Article 13b defence doesn't just stand on its own. It's to use a phrase from Moylan Jr., it's baked into the grave risk element. You can't look at the grave risk without looking at the ways that could be ameliorated. And I'll turn in a moment to the genesis of that, or an authority on that if required. But obviously, the funding of arrangements for grandmother's care is something that the learned High Court judge was thinking about when he ordered the delayed return, which, if we turn to it, paragraph 5084. It may have been a summary decision, it may have been done extemporally, it may have been done in a short form way by referring to only one of the main authorities. But in my submission, the sensitivity that he shows at paragraph 50 and indeed 51 shows that he was thinking about this very carefully and trying to make it, trying to ensure that the policy of the convention was followed. He wasn't saying that takes precedence over anything else. He starts, of course, with why we've signed the convention in the first place, predicated upon summary return being in the best interests of children. But then he turns into how it is that the mother clearly needs time to make arrangements for care for her children, for her parents. Well, it's one parent now, regrettably, but it is one parent. And if you look at what the mother actually said in her evidence about that, paragraph 27, future arrangements, which is at page 98 electronic of the bundle. Because, of course, most regrettably, the mother was dealing with what was likely to happen. It turned out to be the other way, but there it is. It's likely that when she passes away, my father will still require care. However, it will be easy for me to be able to put care into place for him on his own. If he did need to go into a care home, the family home could be sold, etc. And that is something that wasn't available, obviously, as an option when both parents were living there. It now is an option. The position that the mother finds herself in, again referring to evidence which is now in the bundle about the vascular dementia. If the court needs a reference, an up-to-date reference, it's 316 in the supplemental bundle, paragraph 9. This is the grandmother who remains bedridden, suffering from vascular dementia and cancer. And obviously elsewhere, she then says at the bottom, I will also need to decide whether residential care will be required by my mother. Well, of course, and it's an obvious point. This is something the learned judge touched on in his judgment. We are here to deal with the future of the child, and if arrangements can be made, which they obviously can be, and I also mentioned the fact that the brother of the mother, that's to say the maternal uncle of the child in question, visits every day. The page reference to that supplemental bundle 279 at the top. Child sees my brother every day and he sees his cousins 2-3 times a week. The whole family often stay over at weekends. There is support there, and there is a financial mechanism for the mother to finally make plans, if she hasn't already done so, one doesn't know, so that actually the grave risk that's been alluded to by the expert is lessened, because she won't have to provide 24/7 care for her mother. She can make arrangements now, and that she can be released from that invidious position that she felt that she found herself in. If I can turn to the authorities bundle.
Supplementary or the main one?
Well, perhaps I should turn to the supplementary first, because that may assist in going through the.
What point are you dealing with at the moment?
This is, I'm just going to refer to the Hague Convention Good Practice Guide, HCCH Good Practice Guide, which is 48 in that bundle.
What page?
Electronic page 48.
Thank you.
Is my note, yes, got it correct. Electronic page 48 is, obviously this is the guide, and the court will know it full well, produced by the Hague Conference. And it determines the steps, and it's interesting reading, obviously. Paragraph 40, 41 talks about the evaluation of an Article 13b defence, and as I said, using my own Virginia's very apt phrase, it's baked into the assessment of the risk as to whether or not protective measures are available in the state of habitual residence, which we respectfully submit they are, especially with regards to Australia, and I'll turn to that in a moment. And then paragraph 42, once the evaluation is made, where the court is not satisfied the evidence presented, information gathered, including in respect to the protective measures, establishes a grave risk, it orders the return of the child. Interestingly, however, it goes one step further, which I think isn't the case law in this jurisdiction, where the court is satisfied that the evidence presented, etc., is not bound to order the return of the child, which means that it is within the court discretion to order the return of the child nonetheless, even if it finds out that a 13b defence is made out. In this jurisdiction, it's well known that as far as the court's concerned, I think it was Lord Brown in D said, well, if a 13b is made out, there's no discretion to return, surely. But if you go through that process and you look at all the evidence that the learned judge had in front of him, and the new development, as I pointed out, when I say the new development, most aggressively, the death of the maternal grandfather, who my client, in his updated evidence, has said how sorry he is to hear that, and what a fine fellow he was. That provides the practical arrangements can be now put in place that the mother doesn't feel that she's in that invidious position, and that's the genesis, surely, of the grave risk to her mental health. Turning to the other authority that's in that bundle, it's the 1996 convention. Can I just correct our skeletal submissions? We've said that the learned judge referred to the 1996 Hague Convention and the HCCH Good Practice Guide in his pithy judgment. The latter wasn't true. He didn't refer to the HCCH Good Practice. But he did refer to the 1996 Convention, and we respectfully submit that that's important. Of course, Articles 11, temporary protective measures, and Article 26 on raised in that, and that's of course to provide they're to complement each other. And I'm sorry I'm saying these things that I know at least two members of this court know very well. 1996 Convention is to complement the 1980 Convention, and an example of that, having provided that, an example of that is one of the two authorities that we've handed up in written form. It's the printed versions, which is the decision of the then Mr. Justice Cobb in Re A&R 1980 Hague Convention Return to Australia. And I'd ask the court to bear in mind the significant difference in the allegations that were being levelled at the father in that case. You'll see a summary of them in paragraph 10 of the learned judge's judgments. But the reason why we're referring the court to this authority, this substantial first instance authority, is paragraph 60 and paragraph 60 and indeed 69. 60, of course, refers to the 1996 Hague Convention, and as we referred to in our skeleton submissions, it's often the case when it comes to drafting that instead of putting simply that the parties are undertaking, that actually one spells it out and says, well, as if they were orders for enforcement under the 1996 Hague Convention. If I just turn up for your note the paragraph number on our skeleton submissions for that, you'll see why this paragraph 60 is relevant. Just bear with me one moment. I'm aware of the time.
Don't worry. What paragraph 60 says is that if something is within the scope of the 1996 Convention, then that will add to the efficacy of the protective measures. It doesn't address the prior question of what does come within the scope of the 1996 Convention.
It needs to be, well, indeed. These are not points that the learned trial judge had to grapple with.
Why not?
Because he wasn't asked to do so.
Well,
and if we look at page 66, paragraph 66, sorry, 69.
yes.
In that case, of course, there was a number of short adjournments, and she, the mother, agreed that these would mitigate the ways of harm that she feared, and the learned judge didn't get any extra evidence from Australia. He just said he was satisfied the undertakings by the father will be capable of ready enforcement in Australia and will offer immediate protection.
Does it make any difference if you say it's undertaking as if an order? I mean, you took us to the guide to good practice. I thought you were going to take us to paragraph 47, where it deals with the addresses voluntary undertakings and suggests that they should be used with caution because of the fact they're not easily enforceable and therefore may not be effective in many cases. As you may know, that was referred to during the course of the 2023 Special Commission, highlighted in one of the conclusions and recommendations. Just saying something is doesn't make it so if it isn't.
Well, yes, but
So the court here is simply saying that this is a measure within the 1996 Convention. It doesn't make it a measure within the 1996 Convention if another state or another judge in another state will think that it doesn't.
Yes, but with great respect, that's what Mr. Justice Cobb at the time said. Unsatisfied undertakings offered by the father will be capable of ready enforcement in Australia. Will offer immediate protection for the mother from alleged conduct. Take on board what entirely what the court has to say, what the court has said about that. But it may well be that because Australia has, of course, that fact sheet unlike other jurisdictions, about what is available and what's not available, and that's
And it doesn't
referred
refer to undertakings in it, does it?
No, and we don't have that fact sheet, and the trial judge didn't have that
No,
fact
but
sheet.
it doesn't say that undertakings are enforceable
No.
in Australia. Where does Mr. Justice Cobb say that undertakings are enforceable?
About 5-6 lines down, it maybe I'm taking him out of context.
In which? In paragraph 60 or 69?
69.
Do you know what they were? Must be set out somewhere.
56.
Thank you.
Ah, yes, about 56 onwards.
I would have thought they could be varied in some cases.
And a lot of these undertakings, of course, are the kinds of undertakings that were being respectfully sought by the mother, which you can cross-reference, as I said earlier on, page references 105 in the core bundle.
Unless you refer to authority from Australia saying that undertakings made to an English court are enforceable in Australia, I'm afraid to say, unless there's expert evidence to that effect, a judge just saying that is not, with great respect, much help.
Yes, well,
You see, I mean, it's
I agree.
this is a long-standing issue.
Yes,
It's been referred to a number of cases, including the one we've been referred to by Mr. Justice MacDonald. It's been referred to in the Guide to Good Practice. Caution is required when the court considers that enforceability of undertakings is necessary.
yeah,
And in some cases, courts will not consider it necessary for undertakings specifically to be enforceable in the other state, and we'll be satisfied that they provide sufficient protection without that a further safeguard, you might call it. Did Mr. Justice Cobb have expert evidence to that effect?
I don't believe he did, but I can analyse this authority over a short adjournment and see whether there is. But
Well, should
that's
we
why I
stop?
remembered this case, because he
Yeah.
took those undertakings pretty much at face value and said, well, they're
Yeah,
obviously enforceable.
thank you. Well, shall we stop there?
Yes.
And then we'll start again at 2 o'clock.
Yes, thank you.
Thank you.
All right,